I am Greg Lambard, NACM President-elect and current Conference Development Chair. I've had the absolute honor and quite a bit of fun working with the committee and the association staff planning this conference. As you should have seen by now, the theme of this conference is America 250, Preserving the Rule of Law and Judicial Independence. The plenary you're about to see will consider the meaning and importance of judicial independence and the rule of law, and reflect on how stakeholders inside and outside the judiciary can help preserve these important values. They will discuss recent and historical challenges to our constitutional order, including threats to judicial security, declining public confidence in the courts and other institutions. They will also reflect on the resilience of our system of justice and the role that court professionals, judges, political leaders, the bar, and ordinary Americans can all play in ensuring a system of impartial justice. This conversation will set the stage for a series of panels that will consider, during the 250th anniversary year of the American Republic, the foundational principles of our justice system. We have a fantastic, distinguished panel here today. First up, we have Alicia Bannon, Director of the Judiciary Program at the Brennan Center for Justice at the New York University School of Law. She's an experienced constitutional lawyer, an expert on the courts and access to justice in the legal system. Alicia leads a team of lawyers and researchers engaged in policy advocacy, litigation, legislative campaigns, research, analysis, and public education. She also serves as the editor-in-chief of State Court Report, a Brennan Center publication focused on state courts and state constitutional law. And she directs the center's Kohlberg Center on the U.S. Supreme Court. Alicia is the author of numerous nationally recognized reports and pieces of legal scholarship, and she regularly writes and comments for media outlets such as the New York Times, the Washington Post, the Atlantic, Slate, MSNBC, and NPR. She has provided testimony, briefings, and policy advice to lawmakers around the country and taught as an adjunct professor at the New York University School of Law and Seton Hall Law School. Alicia Bannon. I like this guy a lot because he has a really good name. Greg Nunziata is executive director of the Society for the Rule of Law. Greg is an attorney, public policy professional, and veteran of the conservative legal movement. He served as chief nominations counsel to the Senate Judiciary Committee, playing a key strategic role in the confirmation proceedings for scores of federal judges and executive branch appointees. He also served as policy counsel to the Senate Republican Policy Committee and later as general counsel and domestic policy advisor to Senator Marco Rubio. Earlier in his career, Greg served in the U.S. Department of Justice's Civil Rights Division and worked as a litigator in an international law firm. Greg Nunziata. Last, certainly not least, is Beth Clement. She's a former Chief Justice of the Michigan Supreme Court and current President and CEO of the National Center for State Courts. As President of NCSC, her initial priorities include listening to the needs of state court leaders and building actionable strategies to support courts and advance the rule of law. Revitalizing NCSC's mission-driven purpose with strong staff engagement, and diversifying funding streams to ensure sustainability and the growth of NCSC's impact. Beth is widely recognized for her bipartisan approach, her commitment to judicial independence, and her vision for courts that serve everyone fairly, efficiently, and transparently. Beth Clement. So as you can see, quite the panel. Enjoy.
Thank you so much. The mic. Can you hear me? It's on? Okay, great. Thank you so much. I'm Alicia Bannon, and I'm going to be a speaking moderator as part of this conversation. I'm incredibly excited to be here with you at this very important conference and having this very important conversation. And I couldn't imagine two better people to have it with. As the chief noted, we're celebrating the 250th anniversary of the Declaration of Independence, and among other things, the Declaration of Independence included these statements raising concerns about obstruction of the administration of justice, making judges dependent on the king's will alone. I think that highlights the extent to which these values of judicial independence and the rule of law are really baked into our national story, our constitutional system in a very deep way, recognizing that part of what you need in order to make real the promise that all men are created equal, that we are a government that derives from the consent of the governed, is having a court system that is free and fair, having a system that respects the values of judicial independence and the rule of law. There's a long story of challenge and contestation around those values. You might think about the billboards in the 1950s calling to impeach Earl Warren after Brown v. Board of Education. And today, again, we're at a moment where we're in a period of contestation and debate around these critical values. And that's part of what we're here to talk about today. Before we turn to going in depth about those questions, we wanted to spend a little time, since we have our three very different but in some ways overlapping organizations represented on this panel, to talk a little bit about what we are, the organizations we represent, what we do, and some of the different ways that we think about and relate to issues around judicial independence and the rule of law. I'm going to try advance this. Not, I think we're having a little bit of tech issues. I don't know if somebody, pardon? Oh, it's up. Okay, great. Sorry for the delay. We have the tech up. Here's a little diagram to kind of lay out our different organizations. But I would turn to, I guess, each of my panelists to maybe introduce your organization and talk a little bit about how you see the role that you play in this broader field of judicial independence, rule of law, and working with the court systems more broadly. Beth, would you like to start?
Great. Thank you, Alicia. Good morning, everyone. I'm absolutely thrilled to be here with all of you. I'm glad that we're kicking off the conference and that we were invited to join you all to talk about this very important topic, which, as you'll see, is a thread through all of our organizations as well as yours. And we hope that it serves as some inspiration for the rest of the conference and the important work that each of you do. So I am the president of the National Center for State Courts. We are an organization that serves as what I view as the professional home for state court leaders across the country. We provide nonpartisan research, education, practical tools, and hands-on technical assistance to help state courts operate fairly, efficiently, and independently. A lot of our work involves convening judicial leaders, publishing national caseload and public opinion research. We train court executives and managers, and we develop model practices that protect access to justice and the rule of law. As I mentioned, our overarching mission is to improve the administration of justice in state courts so that they're accessible, fair, efficient, and independent. The way that we do that is by being a nonpartisan national organization and that works very closely with a number of organizations, but the ones that I want to note here are the Conference of Chief Justices and the Conference of State Court Administrators. Those are our key stakeholders, and then we work with a number of other organizations that are our true partners, NACOM being one of them. As I mentioned, we do a lot of work with research and data. I'm not going to go through all of the things that we do, but we are technical assistance to state courts. So not just with the Supreme Courts and the state court administrators, but all of the trial courts. We are available to come in and help with issues and progress that the courts are looking to lead on. Greg?
Thanks. My name is Greg Nunziata. I am the executive director of the Society for the Rule of Law. And as you heard in Greg's kind introduction, I have a background in kind of partisan politics and Republican and conservative organizations and work. Our group is a national membership organization primarily made up of lawyers who come from the political right. We are mostly conservatives, Republicans, libertarians, who are united by the belief that we should prioritize the defense of the rule of law, the Constitution, and American democracy above our partisan or policy preferences. So that's how we come to this conversation. We are, as a membership organization, we try to provide a network for like-minded people to connect with each other and to engage in these conversations nationally. We try to bring kind of a right of center perspective to rule of law conversations and a rule of law perspective to some right of center conversations. And that's our work. We go about it in a lot of ways. We have symposiums, we have a regular webinar series, we have a kind of a Substack called Checks and Balances, where we publish thought leadership on these issues, really try to engage in this national conversation. We think it's really, really important, particularly, you may have noticed a lot of the debates about the rule of law today involve criticism of the present administration, and we think these are not and should not be left versus right issues. These are American issues, foundational issues that we hope everybody in this room will champion, kind of regardless who's in political power and regardless of who is threatening our foundational values. So that's what we try to do. We also do advocacy. We do amicus briefs. We do letters to Congress, advocacy on the Hill and in state capitals around the country on a range of issues having to do with the rule of law. We really focus on these things that we think are foundational: separation of powers, checks and balances, and the independence of the judiciary. And the importance of the judiciary to our system is really a huge part of our work and our emphasis, both in our kind of our scholarship and our thought leadership and in our advocacy.
Thank you. And to say a bit about the Brennan Center. So the Brennan Center for Justice at NYU Law is a law and policy institute dedicated to strengthening our systems of democracy and justice. We are part think tank, part advocacy organization, and part communications hub. Specifically with our work around the courts, I direct our judiciary program, which focuses on building a fair and inclusive judicial system that protects rights, constitutional values, democratic values, and the rule of law. We do that in a number of different ways. We are engaged in advocacy, often working with state partners in state legislatures, in the halls of Congress, pushing for reforms or fighting to defend judicial independence values when they're at risk. We do research, among other things. We've done a bill tracking resource that looks at legislative assaults on state courts. So looking at bills in state legislatures that we think are targeting judicial independence. We also look at the role of money in judicial elections and have done a lot of research tracking that. Diversity on state Supreme Courts across the country. So we do a lot of data collection and analysis, which we both analyze, and we also make available to courts, to journalists, to researchers that are using it for their own work. We are sometimes in the courtroom as litigators, so we sometimes file cases or amicus briefs that implicate the values that the Brennan Center is seeking to forward. And then we do a lot of public education and communication around, among other things, rule of law and judicial independence values. And that includes everything from conferences, symposia, engaging with the media, doing other kinds of civic education projects. We're piloting a project right now in the New York City schools. I'll mention one other resource that I think might be of interest to folks in this audience in particular, is a resource that we launched a few years ago called State Court Report. I'm going to see if I can get the slide to advance. is it possible to make the slide? Yep. So State Court Report it's a Brennan Center publication that is dedicated to covering state courts and state constitutional developments across the country. So we have we have a database of state cases that look at developed state constitutional law. We bring in academics, journalists, practitioners to cover state constitutional cases and trends. And we really try to be a hub of information. So we lift up other organizations, including resources by NCSC and others, to make sure that the field it knows all the resources out there to better understand state courts and state constitutions. I have a little QR code. We have among other things a newsletter which you can subscribe to get all of that information right in your inbox. I will end the shameless plug there. But I mean, as I think you can hear, I think we're three organizations that come at these questions from somewhat different perspectives, are in different lanes, but also in a lot of ways overlapping lanes. And I think unified by values including nonpartisanship and a commitment to judicial independence and the rule of law. I guess building on that, I'd love to spend a little time with you all unpacking kind of what those values mean. We talk a lot about judicial independence and the rule of law. How would you each define those values, and how do you see them fitting into our constitutional system? Greg, would you like to start?
Sure, I guess so. I'll just start with judicial independence, and we can talk about lots of other. There are a lot of aspects to both of those questions, but I mean, look, I said at the beginning kind of that our organization prioritizes the defense of the rule of law, the separation of powers, and American democracy. American democracy doesn't exist without those other things. Without the rule of law, without the separation of powers, democracy is just kind of a struggle between two mobs for who gets the power of the state to whack the other side. We are more than that in this country. We have a democracy that is based on law and rights, and the fundamental guarantee of that our founders built into our structure is this separation of powers. Separation of powers comes from a long tradition of thought that the best way to protect liberty was to divide power, to make sure nobody could write the rules for themselves. So we have three separate powers, and always core to that idea, maybe the most important idea, was the independence of the judiciary, that you cannot have the people setting rules or applying the rules judging disputes under the rules. Like, that invites arbitrariness, invites instability, invites much worse, abuse of rights and liberties. So it's so central to our entire country. I really appreciated how it was laid out by the Chief Justice this morning. So it's very central to what we focus on. I think in our times today, from my perspective at least, in our federal government, of the three branches, the judiciary really gets the gold star for continuing to perform its core constitutional function. I think there's a lot of good criticism which we make about the executive overreaching and Congress not doing enough, but the judiciary is really courageously playing its role under, I think, historic attacks. As Alicia mentioned, we've had these attacks in the past, but it's been quite a long time since the judiciary has faced what it's facing today, and it's facing both attacks on its legitimacy, and they come from the left and the right, and attacks on its security that I think are either reckless or intentionally designed to frighten and cow judges and justices. So I'm glad that's not happening, that they are doing their job, and it's we as an organization try to uplift them, and I think that really all Americans do, and people who know more about the court system, who work in it, really are particularly positioned to do that. So I'm really excited to be here to talk with you all and think about how together we can help lift up this story, particularly in this year, because the judiciary, I think, is kind of the undersung aspect of our country and of our rights and liberties. And in the 250th year, we really need to strive to make it kind of central to the conversation, because it really is central to who we are as Americans.
Yeah. So Greg has touched on so much of the foundational pieces of this. I had the great experiences to serve in all three branches of government. I was a lawyer in legislative branch, a lawyer in the executive branch, and then served in the judicial branch. I can tell everyone in this room, the The judicial branch, far and away, is the best branch to work in. And I say that because the other branches were designed to be partisan and to have conflict and to have winners and losers, right? And for the people to vote depending on where the public is on issues, who they want in power. But the judicial branch was never intended to be in that place. It was always intended to be not bipartisan, but nonpartisan. Partisan politics should have no place in our judiciary. And why that's important and why we're talking about that here in this room is because you are all the frontline defense of that very core principle for our democracy. Individuals are interacting with the justice system on a daily basis in a way that they are not necessarily interacting as closely with the other two branches of government. Yes, they vote. Yes, they're following what the other branches are doing, but they are not interacting personally where it's impacting them as closely as when they have a case in our courts, especially our state courts. And so when we are looking at the independence of the judiciary and why it matters, we expect conflict and divisiveness in our other branches of government. Maybe not to the extent that we're seeing it now, but we don't expect that in our branch of government. And so when we see it creeping into that and we see efforts from everywhere to politicize the branch of government, we have to step forward and fight in a way that I think we haven't had to historically.
And I think that's both of your points are so powerful. And as you were speaking, Beth, it made me think of a quote from Justice Sandra Day O'Connor, which I'm going to mangle, but essentially it made this point that there has to be a place where it doesn't matter how powerful you are, how much money you have. There has to be a place where you can just come as an equal citizen, and that place in our system is supposed to be at least the courtroom. And to me, that always struck me as kind of what we should aspire to as we think about building a judicial system that works for everyone. I have nothing to add to the definitions of judicial independence. I was thinking as you were speaking about how that relates to these broader principles of rule of law as well, and maybe we could spend a minute talking about what rule of law means to each of us. I mean, as I was thinking about that question, I guess I couldn't come up with one definition of the rule of law. I kind of came up with three, or at least three components of it. Part of the rule of law to me is that nobody is above the law. No matter how rich you are, no matter how powerful you are, the law has to apply to everyone. I guess the other side of that is that the law should be for everyone. No matter how powerless you might be, we all should have access to our judicial system, access to justice, access to due process. That's another critical component of having a system of law that truly operates as the rule of law. And then to me, I think there's also a systemic component to it, that you need to have all of the different players that operate in our legal system, our judicial system writ large, committed to a shared set of norms and values, operating in good faith, and then being adequately supported, funded, et cetera, so that they can do their jobs appropriately and have a system that is working for everyone and fair to everyone, no matter how rich and powerful or unrich and unpowerful you might be. So that as you were talking was some of what I was thinking about. I'd love to hear your thoughts on what the rule of law means and how it might relate to judicial independence. Please, Beth.
So I think you've hit on some of the big picture and then some of the practical. One thing that I would add to that is that we have an expectation that the judicial branch, judges in particular, that they're deciding cases not based on their personal preferences or what they would like the outcome of the case to be, but rather what the law says that the law, what the law is. And that brings in the other two branches of government. So we can't look at the rule of law in a vacuum just from the judicial branch, because we have to rely on the legislative branch to set, to write the laws. and we have to rely on the executive branch to enforce the law and or the judiciary's interpretation of the law. So we can't do it in a vacuum. We do rely on those other branches, but I do think that the judiciary is the branch that has to keep the foundation of what the rule of law is. And that we're going to have conversations about why we are where we are today and what we can do about it. But I think that, those pieces are things that we have to make sure that we're keeping in mind when thinking about just definitional or foundational.
Okay.
Yeah, I think you've both touched on a lot of the core ideas. But I think it's important that maybe we just step back for a second and just appreciate what law is. We talk a lot about threats to the rule of law, but I don't think we have enough gratitude for what we have in having law. I mean, through most of human history, in most places, your security, your ability to live your life was completely subject to the whims of the people who were powerful. And we don't have to live in that world because of law, right? I mean, law allows us to live in houses with glass windows instead of fortresses with iron bars. It allows us to walk the streets with a pocket full of cash and not a gun in hand. I mean, this is just this tremendous blessing that humanity struggled to get to. We are so privileged to have this system, and it's more than what the founders called parchment barriers. It's more than things written down. It's more than just the idea of a law. There are laws in every country in the world, even in tyranny. It's more than the absence of anarchy. Sometimes people talk about the rule of law just like law and order, right? I mean, there's not chaos on the streets, but dictatorships can give you that. The rule of law is a real cultural commitment to living by processes and not living at the whim of the powerful. It's what allows kind of losers in democracy to accept defeat, and which tells people who have a passing majority in democracy to not abuse their advantage and to respect the rights of those who have lost. And courts are the key part of that, of course, as I said at the beginning, but they really can't do it alone. This doesn't work unless we have a faith in process to resolve our differences, if we have a faith in law, and we have respect for the role that courts play. Courts are crucial, but least dangerous in the sense that they're not the armed branch. They require the culture, the people to support them. They require a citizenry that insists that in this country, the law rules, not any particular man or woman or faction or company or interest. And that's what the business that we're all in when we talk about the rule of law.
Thank you for that. As you were speaking, it made me think, and I think we've all been saying this in different ways, right? That the rule of law, judicial independence requires all of us, right? It requires a kind of shared cultural commitment to those sets of values. And then it also requires adherence to those values by key players in our political system. I mentioned at the start, for example, the Brennan Center has been tracking state legislation that targets state courts. And we've seen really troubling trends of states where a court rules on a particular issue and political leaders don't like that. So rather than trying to change the law, amend the Constitution, they go after the judges. They try to impeach the judges off the bench, not because of malfeasance, but because they just didn't like their rulings. We've seen efforts to politicize judicial discipline, so giving political leaders control over disciplinary bodies in a way to target judges. We've seen lots of shenanigans around how courts are being structured, again, not based on the needs of the judicial system, but in basically essentially efforts to gain more political control over how courts are operating. And so I think it's important when we're thinking about these issues to be thinking not just about the courts in isolation, but also thinking about how judicial independence is going to be responding to outside threats. And there are a lot of players in our system that ultimately have a lot of power potentially to undermine judicial independence and the rule of law. Compliance with court orders, I think, is another dimension of that. Welcome to anyone who has responses to that, or otherwise I can turn to another question.
No, I mean, I think that the inability to accept judicial decisions that people don't like is a real problem. We had a statement of principles that a bunch of people across the country signed on to, that the Society of Rule of Law put out. The ABA, American Bar Association, adopted it as well. And that was one of the central claims there, that it's just really important that we accept the legitimacy of the judicial process. We can criticize decisions we don't like. There are various ways to change the law, and to, over time, change the composition of the judiciary through legitimate processes. But trying to delegitimize courts is a really, really dangerous business. And, I'll say, since I've been thinking about this and working on it, we've seen it on both sides. The Supreme Court, as it swung to a conservative direction over the last several years, got a lot of negative pushback from people on the left, I think, including people who should have known better. When the Dobbs decision came out, reversing Roe versus Wade, decision I happen to agree with, but the rhetoric was really, really dangerous, I think, from prominent leaders. I remember there was a senator, a very prominent senator, who said the Supreme Court has just torched whatever remaining legitimacy it had left. They are no longer a legitimate body. Well, that is tremendously irresponsible rhetoric. And there was a lot of that. And we know there was, an armed person showed up at the home of Justice Kavanaugh, apparently with ill intent. So that was going on the left. And now we've seen this similar stuff on the right, as a lot of lower courts have been ruling against this administration. It is the drive to impeach federal judges for decisions people don't like is tremendously irresponsible. It's an assault on the legitimacy of the court. The rhetoric that goes along with it, you see from senior leaders in the administration calling these judges communists, radicals, subversives, far left activists for just doing their job. And again, you can disagree with the ruling, but these are judges trying to do important work with some difficult questions. Today, in the House of Representatives, outside the offices of some of the congressmen who are leading these impeachment pushes, there are wanted posters for federal judges. Now, the idea is that they're wanted for impeachment, but they're Old West-style wanted posters at a time when the judiciary is facing historic spikes in physical threats. I mean, there's a really, really dangerous road we go down when we respond to decisions we don't like that way. And it's like I said, I like the decision reversing Roe versus Wade. I very much did not like the decision establishing immunity for the president that came up in Trump versus the United States. We had submitted an amicus brief on that. I criticized it pretty sharply in the media when it came out, but I tried really hard, as strong as I disagreed with that opinion, to recognize that these were judges judging and trying to do their job, came to a conclusion I really disliked. But there are ways in our system to reverse these kinds of decisions that we don't like that come out of the judiciary. Talking about judges as though they are just partisan hacks or subversives or threats to the country is opening a box I think we really do not want to open in this country. And those of us who know judges and know how hard they work can really help, I think, tamping down that kind of instinct that too many people have.
I'd just like to touch on the impact of what you're both talking about at the state court level. So we see what's happening at the national level, and it is impacting state court judges across the country. And so if there's anyone sitting in this room thinking, that's partisan politics at the national level, and I try to stay out of that, or I've got, I'm partisan, this way or that way, and it doesn't, and it doesn't matter. It matters to everyone in this room. It matters to every one of our courts, because what is happening at the national level is having an impact at the state court level, in every single state. It is telling the public that they can go after judges in a number of ways, and it is eroding the rule of law and the independence of the judiciary. By saying we can attack federal judges, it has an impact on state judges. And so it's important to know what's going on. And do you have to have an opinion one way or the other, or if you want to stay out of it? But what matters is that you're looking at what both sides have done or are doing and saying, we can't allow this to happen. at the national level, because it comes down to the state level, and then it's going to impact the work that all of you are doing. The last thing that you want is the public saying, we don't have to follow any of the rules that you have in courts, whether that's rules of who can come into the courts, when you can come in, or respecting and honoring the judgments that come from your courts.
Did you want to jump in?
No, but yes, I mean, yes, I mean,
You're allowed to jump
yes,
in.
no, it's sorry to bring politics into it some, but this is the world we live in, and politics is driving a lot of that. But it's so true that this trickles down everywhere. And we hear from judges, state judges, municipal judges, federal judges who are dealing with these kinds of problems and these kinds of threats. It's a real dangerous time, I think. And it's so important that we are all having this conversation. Most Americans don't interact with the judiciary that often, right? So they hear about it with some outrageous case in the news or some politically charged matter, but we all depend on the courts being there, right? I mean, everything, the system that we interact with, our rights and liberties, our business decisions, contracts we sign, rest on the idea that there's a judiciary out there to back it all up. So those of you who work in the judiciary really can do so much good by just helping to explain the work that is being done to our fellow Americans.
There are so many threads to pull from the back and forth we've just had. I guess one thing I'd love to go a little bit more deeper into in our discussion is the issue of judicial security threats against judges. Just to give a little bit more context, in January, for example, an Indiana judge and his wife were shot in their home. And one of the people arrested in connection with the shooting had a criminal trial scheduled before that very judge. Greg mentioned the rise in threats against federal judges. There's been a real uptick in the past few years, including a recent trend of anonymous pizza deliveries made to judges' home addresses, essentially saying, we know where you live. Sometimes those pizza deliveries were given in the name of the son of Judge Esther Salas, a federal judge whose son was murdered by a actually lawyer who was appearing before her. So we're seeing some really scary upsurges in threats against judges and in the security environment that judges are facing right now. So I'd love to talk a little more about kind of what you see, your assessment of the current threat environment for judges, and what needs to happen to ensure that judges have adequate security. Because obviously a key component of judicial independence, right, is that judges need to feel safe in making the decisions, and all court personnel need to feel safe in the operation of our court systems. Excuse me.
So I was kind of touching on that when I was raising my concerns about what's happening at the federal level and the impact that it's having on state courts. And this is what is my biggest concern, is that when you have these criticisms and this attack on the judiciary at the national level, that it makes people feel comfortable attacking judges and court staff and the judiciary generally. And so what we're seeing is absolutely an increase in attacks on judges, an increase in security concerns at courts, outside of courts, at individuals' homes that are judicial officers. And so we are this is one of our top priorities. We are working on a bill in Congress that would allow us to collect all of the information of what's happening across the country at the state court level, because we don't have that. Everything that we know is either anecdotal or it's based on information that is being reported only if states have the ability to collect that information. You compare that to the federal system. The federal marshals have a database. They can collect all of this. They can communicate, and they know when something's happening in one place that it may be happening in another. So you raised the incident in Indiana. There have been other threats. I think of a recent one in Arizona. And unless we're hearing from individuals saying this is what's going on in our state, we can't share that information with other states to let them know what trends are out there, what concerns are out there. So part of it is to be able to collect that information so that we can then share it and have as much information across the state courts as possible, but also to get funding to help with assessments, to help courts identify where their risks are, where their needs are, and really start to build that up. Is it enough to address this across the country? No, but it's a start, and it's where we have to be prioritizing both funding and our efforts to assist not just judges. This bill is for judges and all court personnel as well.
I agree with all that. There's absolutely a need for more money, more resources for both state and federal judges, and for more data. I mean, I think even on the federal level, we don't have enough data. I think one of the problems I find is that some of the judges that at least I interact with, I don't know how common this is, but I hear from judges and from some court staff that almost view some of these threats as normal and just kind of the price of the job, and don't want to speak up and report these incidents. And I think that's a problem. I mean, I think we need to know more about these things than not. I mean, I have one of my friends is a federal judge who just told me recently he's got school-age kids. He lives in an urban area, and he used to walk his kids to school every day. And he just realized that he's got to stop doing that because there's so many threats coming into his courtroom, and he doesn't want to be on a city street in a predictable place every day. And he said this to me with real sadness because this was like a special part of his day with his kids. They had a 20-minute walk to school, and he had to stop doing that. But he's said he's not particularly, raised this issue with anyone in the system. The concerns he has about the threats coming in, he kind of trust somebody else to worry about that. And I wish folks would speak up more. I think both for the government to know where resources are needed and for the public to know what judges are sacrificing in the position they're in. I think it's true. I keep saying judges. It's not just judges. It's all court staff.
Just a brief addition to that. When I was a judge in Michigan, my house was vandalized after a particular decision that was very public and some people were not happy with. And I was also the target of a swatting attack where my husband and I were out on a Sunday, came home. Thankfully, none of our children were home, and there were countless police vehicles there, and they were getting ready to enter our home. What I experienced, just to touch on what your friend was maybe struggling with, is the more that you share that is happening, the more you can possibly draw attention to you and your family. And so I've talked with a number of judges and court staff that have said, I want the right people to know that this is happening so they can address it, but I don't necessarily want this out in the public because I don't want further attention at my home or to the decisions that I'm making. So it's trying to find that balance to address it and to really protect people, but also not make the problem worse.
I'm so sorry that happened. We at the Brennan Center are doing a report right now, an interview-based report, looking at judicial security issues, and much of what you're both recalling are very much align with what we've been hearing as well. Just a few threads that I would lift up from the research that we've been doing. One thing that's come up repeatedly are concerns about family members, and that I think in part as the threat environment has been evolving over time, that increasingly there are concerns by many judges that it's not just themselves but also their families that may be at risk. And I think a lot of the way that in our federal system and in many states we've structured our security infrastructure doesn't necessarily take those risks fully into account, or at least as much as as we need it to. Another dynamic is just how much social media has changed things with respect to the threat environment for judges. And I think that plays out in a few ways. One, just the sheer number of threats out there, right? It's very easy. You could just go online and make some kind of a threatening statement. Many of them, the vast majority of them, are not kind of real threats, but for marshals or in the state security officials that are trying to investigate those, every one of those potentially needs to be investigated. So just the landscape is much, much larger in terms of what security personnel actually need to be engaging with to ensure that judges and court operations are able to proceed safely. We've also seen a real worrying trend of personal identifying information being made available, sort of sometimes known as doxing, people who have, address information that's kind of put online and then prompting these sets of threats. There's also a public policy element to this. And I mention this in part because I looked up New Mexico, and New Mexico's laws are not great on this. So I'll highlight, there are some states that have pretty strong laws on the books in terms of protecting judges' address information. Other states don't. So in other states, it can be very easy. You just look up somebody's voter registration, and you get their home address. And you have then companies that scrape these sites and can put address information up online in ways that can be easily accessible for people who want to target a particular judge. And there's steps you can take. There's examples in the domestic violence context. Most states have laws in place that make it possible for people who are survivors of domestic violence to remove their address information from public databases and can ask, they can create claims. You can go to these companies that collect this information, and if you make a request, they need to remove your address. There's models like that already exist that you could think of expanding and extending to judges and other court personnel who might be at risk. So I think there's also some policy interventions that we could do to help ensure judicial safety. I guess picking up on another thread just around the questions of judicial security and threats, I wanted to, I guess, follow up on something that, frankly, I grapple with myself. And Greg, you were kind of talking about this in terms of how you responded to the Trump v. U.S. case, the immunity case, where you're very critical of how exactly, how should we think about the right ways to criticize, sometimes very sharply, judges or our judicial system. I think one thing, we do a lot of public communications work, messaging, research, talking to people about the courts, and a lot of people, they hear judicial independence, and their next question is, well, what about judicial accountability? And that's an important value too. And I think people want to understand that people want to see that judges are also accountable. And how do you do that right? How do you do that in a way that still respects the values of the rule of law and judicial independence and is attuned to the threat environment that judges are in, while also holding our system to account when maybe they get it wrong?
Yeah, it's not, maybe it's not black or white, it's not easy, but part of judicial accountability for these sorts of things is, opinions. Judges write orders and opinions, and they leave them out for the public to understand why they've done what they've done, and I think they should be criticized on that basis. So, when you have a judicial opinion that you think is a mistake or poorly reasoned, I think we, particularly lawyers or those who are familiar with the judicial system, have a responsibility to criticize it on the basis, on its own basis. Criticize an opinion as aggressively as you want. Say it's wrong, poorly reasoned, but to say that I don't think you should question motives of the judges. I certainly don't think you should say a court is illegitimate or is subversive or something like that.
And I think pointing out that for the rule of law to work, we have a process, right? And that process is not to say to immediately go and say who appointed this judge, whether at the federal level or the state level, and is that what informed their decision? But rather to say, I disagree with how they analyzed this or what the decision was. And there is a process for that, and it is the appellate process. And to educate and then respect that process exists for actual, when you disagree with an opinion that comes from a court.
We've spoken a lot. We've touched on these issues as it relates to state courts, but I also wanted to, I guess, pull on that thread a little more. When we're talking about upholding the rule of law, can you both reflect a little more about specifically the role of state courts in that system and the importance of state courts in protecting the rule of law?
I mean, there's a lot that we can do at the state court level. When I think, thinking just about accountability, I think state court judges have so many different ways that they're held accountable, not just through the appellate process. In many states, judges are elected or have, either, in various forms. Even in states where they're not elected, there's every state has a review process if a judge is abusing their power, and educating the public on that, I think, is the key. I look at this room, and I have to say, as Greg and Alicia do, I talk to a lot of various conferences and a lot of various stakeholders. This is one of the most attentive groups ever. Usually people are on their phones or they've got their computers open. And I mean, every time I look up, everyone is engaged with us. Thank you. And that makes me happy because each and every one of you play a role in what we are talking about. You are closer to your communities than even the judges are. You're closer to the public in a way where not just when they come through the courtroom doors or get on a Zoom and are engaging with the judicial branch, but when you're out in the public and what you can do to educate of the process that is in place, the rules that are in place, that you follow regardless of who is coming in. It doesn't matter if it's some bigwig attorney with a rich client or it's someone that is representing themselves, and that the rules apply equally. And explaining the work that you do can go so far in people having greater confidence and trust in the judiciary. We know that because we have looked at what the public thinks of courts, and when they look at the U.S. Supreme Court and how those numbers are declining. But we collect data and we do research every year, and we see that that's not the case with state courts. And it's because of the work that you're all doing. It's because state courts have an opportunity to do things that federal courts can't do. I'm thinking particularly about problem-solving courts, interacting with the community, with schools in a way that federal judges and federal courts just don't have as much opportunity or flexibility to do.
So yeah, I agree with all that. I mean, there are more of you. State courts handle a lot of really kind of intimate issues that people live with in significant ways that federal courts don't touch. And for lots of cultural, legal, and ethical reasons, there are more opportunities for some state judges and members of the court staff to be out in the public and engage in teaching the citizenry about how courts work. So I think they're hugely important. Also, by the way, election law is a state issue, and that's going to be a contested area this year and maybe for the foreseeable future. So state courts' role in administering election law is really going to be very important to upholding the rule of law in the years to come.
Absolutely. I agree with all of that. About 95% of all cases are filed in state courts. So for most people, their actual personal experience of our judicial system, of the rule of law, is happening in state courts. And, what we've seen is that, not everybody's experience is good, right? Like there's a lot to, how is our court system actually operating in a way that has meaningful access to justice for everybody. And that's the job at hand, to give people an experience of justice that meets that promise. And I think when people see that in their day-to-day lives, then that impacts very much, kind of how they perceive of our system more generally. I think it's really interesting, for example, there's been studies looking at jury service, and when people actually serve on a jury and see how our system works, they come out with a lot more confidence in it. And so kind of giving people those experiences, I think, can make a very big difference in public perceptions of our system. Just to continue, Beth, you mentioned some of the public opinion research the National Center for State Courts has done. So I want to spend a little time digging more deeply into that question as well. We have a recent NBC poll found that public confidence in the U.S. Supreme Court has dropped to record lows, at least as far back they started. They started their poll in the year 2000. At the same time, the National Center for State Courts recently issued public opinion research for 2025, finding that public confidence is higher for state courts than for the Supreme Court, and also that courts are more trusted than the other branches of government. And so, you said a little bit, but I'd love to kind of unpack it more. What do you make of these findings? And particularly, what do you make of falling public confidence in the Supreme Court? To what extent do you think that's a concern for state courts as well?
I'll start with the second question first, and then go to the first. It's definitely a concern. Obviously, that's why we point out when our data contradicts that, because I think that tells us something, and we need to lean into that. But it's definitely concerning because, as Greg said, that's what people are. That are not interacting with the justice system, that's what they're hearing, is what's on social media, what's on the news, are those bigger cases that are happening nationally. And when we're doing this work, we're talking to people that have actually interacted with the justice system at a local level. And so when we look at that, we want to lean into that and say, okay, so what are we doing that is increasing our numbers in public trust and confidence, and how do we do more of that? We do more of that by being more transparent. Historically, courts, back in the day, used to operate as, you have a judge and you have staff, and we don't share what we do. We make decisions, and that's the decision, and you have to follow it. Courts look so different today, and that's a really, really positive step in the right direction. There's more that we can do, whether that's having dashboards that are available to the public for timeliness, and if you're doing your own surveys and asking the public what their impression of the courts is, what their experience has been. It's scary because you're asking people who have are coming in usually for an adversarial proceeding and maybe losers in that, to chime in and say whether or not they had a good experience. And so you think that the natural risk is, well, they're going to say that they didn't if they didn't win. But what we have seen is that that's not the case. If you ask the questions the right way, and you are presenting it, people are honest. And even if they didn't win, but they felt that they were treated with respect, that they were, they had a time, and it wasn't, 5 hours later that their case was being heard, and that things were clearly explained to them, and then they got a decision that was, not legal, mumbo jumbo that they couldn't understand, that they could get the help that they needed every step of the way. That their responses is that even if they did not prevail in their case, that they had a positive experience with the court. So all of that work that you're all doing, we need to do more of that across all of our courts. So even if you're doing it great in your court, we need to share that so that other courts are doing that, because that impact, if we have one court, one bad experience where they haven't gotten to that, it's going to impact the public's impression of the judiciary.
Yeah, no, I think all that's great. And some states, as you know, have formalized processes for evaluating judicial performance, which I have to say, at first blush, I thought that was a terrible idea. that you'd hear a lot of complaints, but I have seen, thank you, that it's been the opposite. I'm particularly familiar with Arizona, where I know the judges all, I think, feel very strongly that it's really helped the public understand and give and vote confidence. And I keep seeing these results as well. Even people who don't prevail in the process come out of it feeling better about it. So all that's good. I think probably more transparency is healthy, and so I encourage more of it. And yeah, I think the collapsing confidence in the Supreme Court and maybe the judiciary broadly is a problem. But this is through our entire country, right? There's collapsing confidence in almost every institution. And I think the judiciary, even the Supreme Court, performs fairly well compared to the alternatives, right? People like the Supreme Court better than they like Congress. So we've got work to do on the judiciary, but I think we have work to do in restoring faith in a lot of our institutions. But I think transparency is a good first step.
You know, I definitely agree that we're facing a broader kind of lack of confidence in institutions more broadly. And I think it's telling that very low bar, right, or performing a little better than our other branches of government. I'll say for me, we talk to a lot of folks about how they think about the courts, how they see the courts. And a lot of times people aren't distinguishing, oh, well, the U.S. Supreme Court sits here and my state court is here and that's this jurisdiction. And people don't understand that necessarily. They just see the courts. And so I do think when people are losing confidence in the Supreme Court, that does have the potential to be reverberating into more broadly how people are perceiving that branch of government. It's also interesting because generally speaking, public understanding of the courts is very, very low. Like people don't tend to know much of anything about our judicial system. At most, they might know the names of like one or two Supreme Court justices. Half of all Americans don't know their state has a constitution, couldn't name any, even fewer could name a justice on their state Supreme Court, for example. And so, I think we also have to grapple with a starting point of really, really low information about what courts are and how they work in our system of government. Another thing that we found that's really interesting is that despite that low base of public understanding about our court system, people do have an intuitive understanding about the importance of checks and balances. So they do get that, it's important to have a branch of government that isn't that isn't a political branch, and that counterbalance is part of what makes our system work. And so I've also found that when you talk to people about some of those basic principles, things like checks and balances, you can kind of bring people along in terms of then thinking about, well, it's important then, like courts play this important role, and so we should make sure that they're adequately funded, and we should not just be impeaching judges because we disagree with their opinions. But it takes a lot of education and work to get people there, because people don't spend a lot of time day to day thinking about courts. And as I said, their base of information is really low. I guess building on that, I'd love to talk a little bit more about what we actually do about that. Like, what are some of what can different stakeholders, both inside our court systems, maybe some of the people in this room, as well as outside, be doing to protect judicial independence and the rule of law, as well as maybe doing some of that basic public education about the role of the courts?
I think there could be more just demystifying of the court process. We talked about transparency. I'd love to see judges and court staff just talking more about what the day looks like, what the job really is, because people really don't know it. They see Hollywood takes on courtroom dramas, and they see political stories in the news. They don't see the day-to-day work that the system is doing. I think more education about that is great. And I think you ought to do that. I think judges, it'd be federal judges probably, but some state and local judges could be on social media and could be sharing kind of a day in the life. I seriously think that would be helpful for people to understand who judges are, that they're real people doing a hard job. I also think that there should be a more organized effort to get other stakeholders involved kind of outside of the judicial system, particularly businesses, particularly small businesses, local businesses, Rotary clubs, local chambers of commerce, who understand the value of a reliable and independent and neutral judicial system to the kind of the day-to-day of American life and prosperity. And getting those folks invested in various programs to defend the judiciary and explain the judiciary, I think would go a long way.
Yeah, I agree with everything that Greg has just identified. You know, this is challenging because I don't know about everyone in this room, but I learned about this when I was in 3rd grade and when I was in 8th grade and then when I was in high school. And then because of what I majored in college, I learned more about it. But we have, basic civics education, and yet it's like people get out into the real world and then they forget all about it. And then you say, when you talk about checks and balances, it's like, yeah, I feel like I learned something about that. Like that means something. And I don't, but they don't recall why. And so it goes back to just core civics education of how our country foundationally was built and what matters and how we get across to the public in today's world. I'm not on TikTok. I'm not going to do TikTok videos. But that's how people are getting their information. They're getting it in these quick spurts, right? And if we're not engaging that in some way, I don't see a lot of judges that are going to want to do that. Federal judges are definitely not going to do that. But we've got to start being creative, and we need to improve on that. To me, that's not going to get us there. I think we have to really invest in the work that we have been doing for decades and continue to do to improve access to justice, to improve the interaction that individuals have with the justice system, because what I would like to see is that there's so much confidence in the judiciary because of what at the local level, that even when you're seeing things that you may be hearing in the news or may be concerning to you at the national level, that doesn't erode your understanding and your confidence in the judiciary.
What do you see as the role that retired judges can play? And Greg, I know you in particular have done a lot of work with retired judges.
I think it's great. I mean, retired judges, they still have a hesitancy to kind of engage in advocacy because they just see it as so different from the judicial nature. But I think it's really important. For lots of good reasons, judges can't speak up as forcibly for themselves in the judiciary as we might like them to. In other countries, that's different. I mean, in Poland, when there was perceived that there were threats on the independence of the judiciary, judges kind of marched on Parliament in their robes. We wouldn't do that in America, I think, for mostly good reasons. But we need to find other ways to speak up for judges, and some of that is associations like this, the people in this room, but retired judges also can be very, very powerful. And I think we've been seeing retired judges organizing in a few different ways in the last couple of years, which I think is a very healthy development.
Yeah, I mean, I think I agree with all of that. I think personally, and I'm curious actually what you think, Greg, in particular. I wish we were hearing more from Chief Justice Roberts. I think that he has a unique platform as well to speak to some of these values, and we've seen a few instances where he's used either his annual report or has spoken out around the role, when judges should or should not be targeted for things like impeachment. But I think that it's a voice that carries weight even now, and that I think we would benefit from hearing more.
Yeah, I largely agree, but I'm sympathetic to the plight he's in. There's some other actors in the country like this too. People who have credibility precisely because they're above politics, I think, are reluctant to do something that they perceive as maybe getting too into politics. So I think the Chief Justice walks that line. The Chairman of the Federal Board of Reserve has walked that line as well, trying to defend the independence of the institution without looking like you're day to day in a daily fight with political actors, and then become seen as a political actor yourself. So I think it's a challenge. I agree that I think I'd prefer him to lead in a little bit more, but when he has spoken up, I think it's been very powerful.
I'll speak to, I guess, just thinking about some other kind of players in our broader system and the roles that they can play. As I said, the Brennan Center has done a fair bit of work in states where we're seeing often legislative efforts targeting judicial independence, targeting judges, and so I've had a chance to kind of see firsthand some of the work that folks outside the system have also done in support of judicial independence values. And that's been everything in Montana right now, where there's been a number of bills introduced and passed, for example, politicizing judicial discipline, seeking to make their elections partisan, issues around compliance with court orders. There's been kind of a lot of very highly politicized atmosphere in that state, and there's been some really interesting work. So, for example, you had work among the state bar has been very active in public education efforts. You had, and I think one of the lessons here is you've had kind of cross bipartisan groups that have come together to speak about what are the core kind of constitutional values in their state, what is the role of the court in that system. One of the things that was coming up repeatedly is that we talk about the public not knowing a lot necessarily about the courts, how they operate. Sometimes state legislators don't know that either. They're not necessarily, many of them aren't lawyers. Many of them haven't spent a lot of time always thinking deeply about our constitutional system and really the role of courts. So I think there was actually some really effective work done in that state around real public education, and then also education of state legislatures about exactly the role that Montana's courts play in their broader constitutional system. I think another thing that the experience is there, and obviously this is an ongoing story, but I think another thing that people found was when you're talking to ordinary people, you really need to make those connections to their lives in a very kind of concrete bread and butter way. So these are rulings that this court is making, and this is what it means for you, for your family, for your education, your education system. I mean, and in some ways it's easy, right? Because when you step back and look at all of the different ways, particularly our state courts are impacting people's lives in all different ways, but people aren't always making those connections. And so there was a lot to do, and continues to be a lot to do, to really reach out to people in those communities and find people who are going to be persuasive and trusted in whatever communities you're engaging with, to help make some of those connections and speak about those judicial independence values. And like I said, that's work that is ongoing, right? The fights aren't over in Montana, but it's been interesting where there's been, I think, there's been more success than you might have expected from an initial climate that was very hostile to the courts in a lot of ways in doing some of that public education and standing up for judicial independence values in the state.
Yeah, I think what you said is really important, that we always need to remember that we need to make the case for judicial independence and why it matters and how people benefit from it. I think too often we assume that everybody knows that, and we focus our efforts on talking about the threats and opposing threats, but we got to start with explaining what we have. And I think that's really a useful story about Montana, and that's part of what I was saying about why I want businesses and other local stakeholders to be explaining how they benefit from the court system and what services it offers.
I just want to follow up on the example that you gave from Montana, and how important it is to say, to look at when there's efforts in a certain state in that way, making sure that other states know that that's happening, so that if they are not experiencing that and things are going well, that they are actually doing the work ahead of time, so that they're not waiting for that to arise and that to bubble up in their state, but to say, okay, this is where we could be heading with something. Let's get ahead of that by doing some of those pieces and being, playing offense instead of defense. And that's been very effective.
I think that's such an important point, and especially when so much of what is required is this groundwork of public education and engagement about these values that takes time. I think one thing we've seen in some of the states that we've worked in is that, especially some of the changes, when you're having courts being targeted, it can feel very wonky and technocratic, and it's really hard to get people animated about, oh, you're changing the membership of a judicial disciplinary commission, go light the torches and fight. It's not necessarily something that people will understand off the bat. And so I think having some of that work to educate both, thinking within the court systems, being prepared to be engaging and advocating for judicial independence values, and then for those of us who are working on the outside, engaging with different stakeholders so that they're monitoring what are happening, they're educating their communities, and so people are seeing this as kind of a long-term investment and commitment in building a culture of rule of law and judicial independence. I guess we wouldn't be, at any kind of court conference if we didn't at least briefly talk about AI. I feel like that's something that comes up everywhere. So I'd be curious to hear your thoughts, as we've been talking about different ways of enhancing access to justice, and transparency and the like. How do you see technology, including AI, playing a role in improving access to justice and promoting rule of law?
So this is another thing that we need to constantly be working on to balance. There are a lot of incredible benefits to AI when you're looking at the judiciary, you're looking at the court system. Online filing, virtual hearings, plain language information, language access, triage tools, things that improve access. And I think we are just beginning to scratch the surface of where we can really utilize this. At the same time, we know that the public generally, leave the courts out of it, the public generally is fearful or skeptical of artificial intelligence. We have a lot of people that are interested in it, but the majority of the public is not trusting in this new tool. So how do we balance that, where we're bringing it in, using it where it can be beneficial to improve access to justice and help support the work that we're doing, but not then negatively impact either the rule of law or the confidence in the work that is being done. And so we have to constantly be looking at it from both lenses and making sure that we're balancing that. Because the worst thing that could happen is to fully embrace something and then have the public say, we don't trust the judiciary. We don't trust what is going on because of the use of AI in these various ways. So we have to be very thoughtful about it, but we also can't say we're not going to use AI at all, and it's not going to be part of our process and improvement going forward.
I don't know about I have anything to add about how it works within the system, but I do think AI is powerful for potentially explaining the system. I've seen some AI summaries of judicial opinions in plain language are surprisingly good, and I think it's always been a criticism I've had of the media. It does a terrible job of explaining what courts do. I mean, just an awful job. They rarely even link to the opinion, and of course, opinions, when they do link, are not very accessible to the average person. And the media tends to hit whatever feels newsy, but not explaining the logic or the reasoning of the opinion, which is really what's important, and that's the real work of what the courts are doing. And AI has been just very good at giving plain language explanations for judicial opinions, and I hope that expands and is used more widely by the public.
We only have a few minutes left, so I'm gonna ask. I'm gonna turn to our lightning round questions. The first would be, what is one change or reform that you would like to see implemented in the next year? So you got a short timeline to promote judicial independence and the rule of law.
I'll start, and I've already talked at length about it, but judicial security. I think we have to, while we're taking two tracks of educating the public and making sure that we're doing everything that we can, and the work that you're doing each and every day, we also have to, realize that judicial security is a top priority, and we need to address it because without judges and court personnel feeling safe, we're going to lose, and we already have lost people from the courts and we can't continue to see that erosion because the more that happens, the bigger impact that we'll have on the rule of law.
Yeah, I think security is really the only reasonable thing we can expect to happen in 12 months in terms of policy changes. The only other thing I'll say, which I said before, is that I just think we really need to take the opportunity this year, those of us who think about and worry about the judiciary, to be advocates for it and to make the independence of the judiciary a real part of our national story in this 250th year. And the judiciary largely is not going to do it for itself. The judges aren't. People like us, people in this room, can't do that. And we ought to try to do that in our communities wherever we can.
I was also going to say judicial security. We're agreeing vehemently, and I'll just to add to that, just lifting up the bill that Beth mentioned earlier. There is a bill introduced in Congress with broad bipartisan support. It is, I believe, passed the Senate already, countering threats and attacks on our Judges Act that would establish, among other things, a state judicial threat intelligence and resource center. I think that's something, it's certainly not enough, but I think it's a very concrete, practical step that, that could be taken. And I hope we will see more progress on that. And I would lift up as well what I was saying earlier about states also looking more closely at how they do or don't protect personal identifying information of judges. Again, I think there are big structural things that are going to take a long time to address in terms of better protecting rule of law and judicial independence. But I do think there are kind of discrete, targeted interventions that can make a big difference day to day in people's safety and the functioning of the system. My last lightning round question, and then unfortunately we'll have to end this really wonderful conversation, is just what is one thing you would like the members of our audience to take away from this conversation? Beth.
What I would like you to take away is that you have representatives from 3 very unique, distinct organizations that wanted to come here and talk to you about this very important topic. We all play different roles in the system. NACM and the work that you do plays a unique role in the system. And it is so vitally important that we are working together, having these conversations. I know that the 3 of us don't agree on everything. We don't have to. Look at all of the things that we do agree on and the impact that those conversations, those collaborations, and that those partnerships can have on the efforts that we're here to improve.
Yeah, just the court system is kind of the keystone of our country and our liberties, and it's what makes it possible that people who disagree even vehemently about things can live together, not just tolerating each other, but productively together as fellow citizens. So you are all part of this important keystone, this pillar that is still a mystery to a lot of America. So you have both a responsibility and an opportunity for holding that up and doing the hard work that the judicial system does, but also to be advocates for it in your communities as both in kind of substantive advocacy and also just in educating and demystifying. And you're so uniquely positioned to do that. And thank you for all the work you do.
And I'll just say, really just echoing what Greg and Beth said as well, is judicial independence, rule of law, that takes all of us. It takes our organizations, it takes all of the people in this room, and then it takes other, our political leaders, our bar leaders, our community leaders, and just ordinary Americans kind of recommitting to these ideals. And I think we have our work cut out for us, but I also think I was really inspired by the conversation we had today, because I think it just highlights all of the ways that all of us have a job to do and have really concrete ways that through public education, through enhancing transparency, democracy, through ensuring that people's experience in our court systems are positive. All of that are those building blocks to preserving and restoring these critical values that are really a bulwark of our democracy. It has been such a pleasure being on the stage with you all, and thank you to the audience and to NACOM for bringing us together today. So thank you, and enjoy the rest of the conference.
Thank you.